Hi everyone, we're gonna give it a couple minutes to get started here. Let people continue to join. We'll give it a couple more minutes. Oh, here's Katie. Wonderful. All right, we will go ahead and get started. Good afternoon, everyone. Thank you so much for joining us today for AAPD's webinar, Protecting Disabled Students, Part 2. What is disparate impact and why do we need it? This is a follow-up to a previous education policy webinar regarding the Department of Education, which you can find on our YouTube channel, and we will put the link to that in the chat if you were interested in viewing that. My name is Michael Lewis. My pronouns are he and him, and I am the Vice President of Policy here at the American Association of People with Disabilities. For a visual description, I am a white male in my late 30s with brown hair, and I am wearing a button down shirt that has a pink and white gingham pattern. A few brief housekeeping announcements. This webinar is being recorded and tight and ASL are provided. To access the caption, please click on the CC icon button on the toolbar at the bottom of the screen. The interpreter is spotlighted, but please let us know if you cannot see them. Please also avoid using the chat unless it is an urgent accommodations related message. There will be time for questions and answers at the end. To submit a question, please type it into the Q&A chat box, which is also on the toolbar at the bottom of your Zoom screen. Lastly, if you were here as a member of the press, please note that this webinar is closed to the press. However, you are welcome to stay in your individual capacity. We will be recording the webinar and sending it out to all who have registered along with any follow-up material. And without further ado, let me introduce our panelists today. First, we have Eliza Armstrong, who is a disabled advocate and a Stanford University law student who founded Equal Opportunities for Students. We also have Sam Bagenstadt, who is a civil rights attorney and former general counsel for the U.S. Department of Health and Human Services and the Office of Management and Budget during the Biden administration. Professor Bagenstadt currently teaches at the University of Michigan School of Law. And then we are also joined by Katie Neat, who was the CEO of the ARC of the United States, as well as the former Deputy Assistant Director of Education for the Office of Special Education and Rehabilitative Services during the Biden administration as well. So without further ado, let's dive right into our questions. The first question is for um Sam. What is can you provide some background and discuss the executive order that restricts the use of disparate impact in education? What does it entail, and is it even legal?
All right, thank you. And yeah, this is a really great crowd here. I'm really happy to be able to give some explanation about what is going on. So on April 23rd, so just over a month ago, President Trump issued an executive order targeting disparate impact in civil rights enforcement. So let me just start with what is disparate impact, just to get us all kind of in the same place here. So usually we think about discrimination law as something that targets intentional discrimination. I'm treating someone less well than someone else because I know the person I'm mistreating has some characteristic that runs along a protected axis. So because of their race or because of their sex or because of their disability or religion. And that is called intentional discrimination or sometimes disparate treatment. But for a long time, the law has recognized that there are lots of circumstances where we have significant issues of inequality that really are discriminatory, but that don't fit that intentional model. And for those, the law has crafted this doctrine of disparate impact. And the basic idea of disparate impact is when you have an entity who is covered by the civil rights laws and they do something that has a disproportionately harmful effect on a particular group along lines protected by the civil rights laws, so a particular racial group, particular sex, particular disability group, if there is that significant adverse impact to a particular protected class, and the entity covered by the civil rights law can't provide a sufficient justification for what it's doing, then we have a violation of the law that is discrimination. And so the Supreme Court first articulated the disparate impact doctrine in 1971 in a case called Griggs versus Duke Power, which involved an employer in the South after the adoption of the Civil Rights Act of 1964, which stopped discriminating formally on the basis of race in deciding who would get particular jobs, but imposed a new requirement of a high school diploma or passing a pen and paper test, which, because of then existing state discrimination in schooling in North Carolina, where this case arose, would necessarily have a disparate effect on African Americans. The court said, yeah, you have to justify doing that. If not, it's discrimination. Since Griggs in 1971, Congress has incorporated disparate impact prohibitions in a number of laws, most notably for our purposes in the Americans with Disabilities Act, although courts have said that it's also a part of Section 504 of the Rehabilitation Act, also a part of the Fair Housing Act, which protects against disability discrimination. So disparate impact is important for individuals with disabilities. Now, disparate impact needs to be distinguished from reasonable accommodation, which also is an instance of something being determined to be discrimination by the law, but that doesn't necessarily involve singling out someone for different treatment because of their status as a person who has a disability. But that's much more individualized. That is, an individual who is disabled cannot have access to a particular opportunity because of the way that opportunity is designed that happens to exclude disabled individuals. And so therefore that individual needs an accommodation in order to get equal treatment. The law has tended to treat reasonable accommodation separately from disparate impact, separately from disparate treatment. Well, on April 23rd, Donald Trump issued this executive order that targets disparate impact, that first of all says it's the policy of his administration to eliminate the use of disparate impact liability in all contexts to the maximum degree possible, to avoid violating the Constitution, federal civil rights laws, and basic American ideals. That's just a quote I'm reading from the executive order. That's the policy. Eliminate the use of disparate impact liability to the maximum degree possible. Then it imposes a series of obligations on his administration. First of all, it eliminates presidential approval of disparate impact regulations the Department of Justice issued under Title VI of the Civil Rights Act, so governing race. So this doesn't specifically have to do with disability. It requires all agencies within the federal government to deprioritize enforcement of disparate impact prohibitions. So basically enforce everything but disparate impact prohibitions before you get to disparate impact, which means effectively they'll bring no disparate impact cases and they'll dismiss the ones they have. And it requires the agencies within the executive branch to go through, and the EOC to go through their existing regulations and take steps to get rid of the existing disparate impact regulations they have to the extent possible. So that's the basic idea of the executive order. You know, most executive orders don't do anything immediately. They instruct the administration to take certain steps, which will then be realized in weeks or months, which is true of this one as well. A couple of things that are important here, and then I'll move on to the next speaker. One is that the executive order singles out a number of regulations and statutes that it is saying need to be changed or need to have changed administration policies under. It does not single out the ADA or the Rehabilitation Act. It singles out statutes that are largely, if not exclusively, about race. That's clearly the target here, and a lot of the rhetoric in the executive order is about how unfair and unconstitutional it is to have a disparate impact prohibition in the context of race, even though the Supreme Court has articulated and upheld that prohibition in the race context for years. But again, a lot of the language is about race. The specific statutory and regulatory references are about race. But there's also very general language in the executive order that says eliminate the use of disparate impact where possible, wherever possible, deprioritize enforcement of disparate impact, all of which would certainly reach the disparate impact prohibitions under the ADA and under the Rehabilitation Act and the disparate impact prohibition for disability under the Fair Housing Act. So although disability does not seem to be the target of this executive order, it could clearly have an effect on the enforcement of rights of disabled people.
Thank you so much for that, Sam. This next question is for Katie. How did disparate impact liability affect the rights of disabled students, such as those that are guaranteed under Section 504 of the Rehab Act and IDEA?
Thanks, Michael, and thanks for having me today. I want to reinforce something that Sam said that I believe strongly, that race is the primary target of this executive order. And so I want to just take a step back and just remind folks that students with disabilities come from all races and ethnicities. Students with disabilities are general education students first. And students with disabilities have historically been subject to discriminatory discipline more than their non-disabled peers. And within that, students with disabilities who are Black are really disproportionately subject to disciplinary practices. The U.S. Department of Education, under the Civil Rights Data Collection, every 2 years works with school districts to find out sort of who's where and doing what. In the last data that we have is the 2019-2020 school year. Black children with disabilities made up 17% of children with disabilities, but were 43, almost 44% of all the children with disabilities who were suspended out of school or expelled for more than 10 school days. One of the things that we as advocates have used this data to look at is to look at how are these laws being implemented? Are they being implemented with fidelity? Are kids' rights, are kids able to access the rights they have? And over the years, the question has been asked about what does this mean within the special education context? Almost 3 decades ago, we put a policy in IDEA on disproportionality. And it was, why are there so many kids of color that are being put in special education when maybe they shouldn't be? And conversely, are we doing a good job of meeting the needs of these students before they if they're on the edge of being eligible for special education, or they just need a little extra help? There's a provision in IDEA that requires states where there is a high level of kids with disabilities from ethnic and racial backgrounds, that if they are falling behind, that the state has to, or the school district has to direct 15% of IDEA funds to assist them. Those policies have been in place because there's a pragmatic reality that a lot of students with disabilities of color have not been able to access their rights under the law, and that there were fundamental practices going on that we wanted to give schools the resources to address. So those are really, really important elements that have been in our laws. And I think that while this EO on first blush looks like it doesn't affect people with disabilities and students with disabilities, either under 504 under IDEA, it does, right? It does. It has the potential to do that. And we have a long history of certain categories of kids having a more difficult time accessing their rights under the law. We need more attention to why the laws are not being implemented properly, and what supports do states and districts need to do the job that's very clearly outlined in the law. The last thing I'll say, just as a friendly reminder, to be eligible for services under the Individuals with Disabilities Education Act, a child has to, 1, have a disability, and 2, need special instruction. It isn't enough, just enough to have a disability. You need to also need special education services. For kids who are eligible for supports under Section 504 of the Rehabilitation Act, they have a disability. They need accommodations. So it's a kid with diabetes that needs to be able to eat whenever the child needs to eat to make sure their blood sugar is appropriate. Or that's an easy one. So that child doesn't need special instruction, but that child needs to have the rules that say we don't eat in classroom not applied to him, so that he can maintain his health and learn. So the EO is so broad, and yet while we have statutory requirements, I think what's in the air is people hear what comes out of the president and think that it's equal to, yeah, statutory requirements, and it's just not. And so I think we as advocates need to continue to work with our communities to make sure that these laws are appropriately implemented, that children and families get the supports that they need, and that these executive orders are not and it used as an excuse to not do what the law currently requires them to do.
Thank you, Katie. As a quick follow-up to that, how would removing or limiting the use of disparate impact liability affect the ability of school districts and state and federal education agencies to enforce the rights of people, of students with disabilities?
So under the previous administration, guidance on to reduce the use of discriminatory discipline policies on students with disabilities was released in July of 2022. And the reason the administration did that was we were just hearing from states and from families that people were unclear of what their responsibilities under the law are. And I think that continues in many aspects of the law today. I always say there are 7.5 million students receiving services under the Individuals with Disabilities Education Act. So we have 7.5 million opportunities to get it right and 7.5 million opportunities to get it wrong. And when you have mortals implementing laws, then sometimes they make mistakes. And one of the things we want to make sure is that we can cut down on the numbers of mistakes. And unfortunately, those schools that have fewer resources sometimes have more mistakes because you have classrooms that are too big or teachers that don't have the training or support. There are lots of reasons that. So when you add on the sort of the thought that that's being promoted by the executive order, that somehow doing more for people who aren't getting to equal, right? Because the IDEA is all about helping kids get to equal, not more, not less, but to equal with their non-disabled peers. And sometimes that takes more effort, right? And more effort can be perceived as being disproportionately inappropriate, and it's just not. So I think that's one of the things we want all of us to take to heart, that again, we want to make sure these laws are being implemented in accordance with the statute and regulations, that people understand their roles and responsibilities, and that students with disabilities fall into every protected category of people.
Thank you so much, Katie. This next question is for Eliza. Eliza, you have fought for your rights as a disabled student, and you've encouraged many others to do the same. Did disparate impact come into use there? And what would it have meant for you and other students if you were not able to claim a different impact?
Yeah, thank you for inviting me. I also wanted to echo what the other panelists have said, is that this is one of many executive orders that are targeting race that have been coming out of the Trump administration. And it's not just the Trump administration. You see it happening in my home state of Florida. You see it happening in a lot of places. Um, I grew up in Florida. I'm an epileptic. The shortest possible version of my story, because I don't want to bore you all, is that the lights in my math classroom flashed. The school told me that they didn't do accommodations. They told me that in writing, and they said that I'd have to leave the school. So I ended up having to take legal action against the school. Now, the thing is, with most people, they're not dealing with schools that are, willing to say something like that so boldly in writing. Like that was a, something that I received that most people don't. Um, and that's part of disparate impact as well, right? Is that that's sort of a lot of the time what you're looking at in sort of terms of discrimination. And I think also something that I've noticed, especially in education settings, when we're talking about, disparate impact and we're talking about, certain students get sent to exclusionary punishment more often. Certain students are, excluded from higher end classes. Um, we oftentimes talk about that in terms of like implicit bias, but something that I think is also important to recognize is sometimes that's explicit bias. Like there are very much times where people will acknowledge like openly not like a race of people, openly not like someone because they have a disability. But if they don't say that explicitly, where does that lead you? Where does that lead you to go? So if theoretically I were to run a school district and I did not like that there were disabled students in my school district, if I were to systemically funnel them out, but not call them out for it, not explicitly say like they did in my case that, hey, we don't want you here on the basis of your disability, it's so much harder. And I think that's part of the problem here is I don't want to impute bad faith on everyone. I know a lot of really talented, really caring educators, but at the same time, these laws are in place because there are people, as we all know, as people who work in disability spaces, and I know as a Black person, as I'm sure people with marginalized identities know, there are people who act in bad faith. There are very much people who act in bad faith, and the standards that courts use for racially neutral is, I'm not racially neutral, I'm sorry, facially neutral is comically low, like very comically low, essentially to the point where if you're not explicitly discriminating against somebody, it can be justified as a facially neutral issue. And when I was working on the Human Armstrong Award, I used to run a scholarship with Judy. Stopped it this year because I'm in my 1L year at Stanford right now, but planning to bring it back later. But that's a different conversation. I talk to students a lot, and students would oftentimes uh, talk about how at their school, at their college, in their district, about how there were all of these policies in place that, all of these kids are in one different classroom and they don't get to have all of the other opportunities. They don't get to go to recess. They don't get to have, the same educational opportunities, and that follows them the rest of their lives. And that's a very serious thing. Like if I hadn't been able to get my high school education, I'm definitely not at Stanford right now. And like these are serious issues that have serious consequences, and we have to understand that the issue of disparate impact is pretty much essentially the core of being able to bring discrimination claims. I've heard it constantly from many different students that I've worked with over the years. It's a really important issue. And again, I just want to say that we're not just talking about, you know, preventing people who, mean well and want to help. We're also talking about people who have some really, really, frankly, bigoted beliefs, and the law is meant to prevent them from doing that. And if they have bigoted beliefs and don't want to say so explicitly, without this standard, the law sort of puts them in a gray area where there's not really much that can be done. So I want to pass it back.
Thank you so much for that, Eliza. This next question here is for Katie and Sam. Can you name other ways or examples in which this executive order would specifically impact disabled students and their families?
You want to go first, Katie, or you want me to go first?
Why don't you go first?
Okay. So I'll leave a little bit of time. So I think that what's important here is this executive order is probably not directly going to do anything because, executive orders are sort of glorified press releases and instructions to agencies. So you won't see something tomorrow where there's necessarily an immediate harm to disabled kids or disabled people generally. Directly as a result of this. However, a couple of things. One, as Katie said before, the executive order sends a signal, and a lot of people don't appreciate, I would say most people don't appreciate, an executive order is not a statute. An executive order often has little, if any, legal effect. What it is, again, is an announcement of administration policy. And so people see the president putting his name on something like this, and they start to say, oh, aha, I don't have to follow disparate impact law anymore. That's the real concern, is that the signaling effect of this is going to get people to back off their adherence to the law. A couple of areas that I'd be worried about. I mean, obviously we've talked about educational areas, and that's really important. That's the topic of this webinar series. That's what Katie talked about. I, worked for the last few years of the Biden administration, excuse me, in the Department of Health and Human Services. The health equity area is an area where disparate impact has been extremely important for people with disabilities. When we're talking about challenging structures of benefits, for example, that may exclude or effectively deny coverage to people with disabilities, but that may not be, specifically formulated in a way that explicitly excludes disabled people, not having disparate impact could be a major problem there. I think also, to pick up on a point that both Katie and Elijah really talked about, the intersectionality point is really important here, that there are lots of circumstances where the inability to use disparate impact for race is actually going to have a substantial and disproportionate effect on individuals with disabilities. And so, and that's because of a substantial overlap. And, I think about the case that the Biden administration brought and the Trump administration pulled back and actually dismissed in Alabama, involving raw sewage being dumped on people's lawns, right? This is something that the explicit basis for this case was that it was a violation of Title VI of the Civil Rights Act. It discriminated on the basis of race. But when you have raw sewage dumped on people's lawns, that also is going to disproportionately affect individuals with disabilities who may have pre-existing conditions that may make them more susceptible to infectious diseases and otherwise. And so I think it's important to keep in mind, even the non-disability parts of this are going to be important for people with disabilities.
And what I would add to that is the cumulative effect of certain actions from this administration. So on March 11th, the administration reduced by about half the employees at the U.S. Department of Education. They closed many of the regional offices that housed the Office for Civil Rights staff that investigated discrimination on the basis of disability and other forms of discrimination. The largest sort of bucket of complaints that OCR has received over the last several years has involved disability discrimination. So they've made acting on those claims of discrimination that much more difficult because there are fewer staff who have more work to do. And then on the 20th of March, the executive order to dismantle the Department of Education came out. And then we got some good news. The end of March, a group of school districts and teachers unions in Massachusetts filed a federal court case challenging under the Administrative Procedures Act, the legality of that executive order and the actions of reducing those staff. And then just last week, the court, in a preliminary injunction, ruled in favor of, ruled against the Trump administration, and it's now under appeal. But you put all those things together, and what we heard after the staff was laid off and right after the EO was families were hearing from schools, well, your IEP isn't really valid anymore, and no, we don't have to follow the due process rights. And there was all this misinformation. So I think the following weeks with the disproportionate impact EO, it's all building on top of each other to try to undermine the fundamental civil rights protections that people have and for students in public schools. And so it's not one thing per se, but it's all of these things in combination that are creating this environment where the civil rights laws are maybe perceived by some as optional, right? They don't really have to follow them. They really don't have to meet their obligations under them because there is all this uncertainty. And I think we're here to say is the laws are still the laws and you still have the protections, and just because they have these executive orders doesn't invalidate the laws.
Thank you, Katie and Sam. The question is open for any of the three of you to answer. Is there a difference between how K-12 and higher education students might be impacted by this? And also, what did this mean for children that are enrolled in private and parochial schools?
I can jump in, Elijah, if you want to add anything. So kids in K-12 are covered by both 504, the ADA, and in the Individuals with Disabilities Education Act. Kids in higher ed, and I'm sorry, I'm old, so they're kids, young adults are protected in most instances by 504 and by the ADA. When I started my career many moons ago working on the original Americans with Disabilities Act, and we get calls from colleges and they'd say, now, if this law goes into effect, does this mean I have to make our programs and services accessible? And I'd say, no. And they'd go, great. I said, you should have been doing it since 1978. And they go, oh, right. So some of these things are not new. And so for students in higher education, those universities, if they receive federal funding of any sort, and most of them, nearly all of them do, they have to provide accommodations for students, and they have to make sure their services are accessible to and available for students with disabilities. They don't have the same rights to specific services on an education specific way, the way that K-12 does. They still have the rights to accommodations. And I think schools are better at doing it than they were 30 years ago, but I think we still have a long way to go. But again, I think it contributes to that as I was saying, the instability in the universe, that somehow with these things that you can do less, when I think, in fact, what we want to see is more schools doing more, especially for college students. I think the other thing I would say is some of these the entrance exams, the SAT and those things where people, and particularly like LSAT and med school exams to get in for entrance. I mean, I think the notion of accommodations will be one thing we'll want to keep a close eye on. Again, those are required under the law, and you just because all this stuff is out there doesn't mean that those obligations go away.
Yeah, and I'd just like to add that in K-12, at least, most of the disparate impact stuff seems to be in areas of exclusion, areas like punishment, areas like not allowing students into specific schools, not allowing students to have access to specific course materials. And I can't really think of, at least in the students that I've dealt with, like specific areas of disparate impact once the students are in higher ed, but actually getting those students into higher ed, period, is one of those circumstances where like a lot of those students who have those experiences are unable to go to certain schools because of, just the overwhelming education discrimination they've experienced, or because the campus itself is inaccessible, or because the housing is inaccessible. Um, and like all of the recreational stuff is inaccessible. So even if they're a part of the school, they aren't able to like engage with their peers the way that other people are. So there are all of these things that like are really, especially in higher ed, within like the gray areas of the law that definitely hit the disparate impact standard, but that are already even before the executive order areas where the Department of Education really struggled to sort of crack down just in these sorts of areas, and that would only worsen with the executive order going forward.
Professor Bagenstat, would you like to speak how the to how this might impact the 10 private and parochial schools?
Sure. There are a number of the civil rights laws that are covered by this executive order that affect private and parochial schools. So Title VI, Section 504 may affect private schools that receive federal funds. The ADA certainly covers private schools. Now, there are often a lot of exemptions for religious entities, both explicitly in the law and in various doctrines that have been created by the courts, or various other provisions of other statutes like the Religious Freedom Restoration Act. So already when we're talking about parochial schools, there are limits to the degree to which, as a practical matter, the civil rights laws will apply. But I think you will see, in this context, there are private school students who will be covered, who will be affected. There are some parochial school students who will be affected. Of course, every child has the right under IDEA, every disabled child has the right to a free, appropriate public education. And many get that through going to a private school and having it reimbursed. And there's already very substantial issues about how to make sure that the quality of education is good there. But yeah, this will have effects all across the board. But again, I think it's really important that we understand two different things here. One, the executive order is going to have an effect in the world because of its signaling effect. But two, we shouldn't add to that signaling effect by treating the executive order as having a legal authority that it doesn't have, or having legal effects that it doesn't have. So, I think it's very important to understand that all of these disparate impact prohibitions remain on the books. The only legal change that's made by this executive order has to do with specific regulations under Title VI adopted by the Department of Justice. Everything else is still on the books, and it's just about telling the administration they should undertake a process to move away from disparate impact. And I think that's something that advocates of civil rights and of justice need to be pushing back on, and should not be just assuming that the game is over because the executive order has been issued.
Thank you so much, everyone. And this last question, what is the best way to continue fighting for our civil rights and disability rights? And what can we all do to best protect disabled students? And whoever would like to jump in first is welcome to do so.
Well, I would just say people need to know what their rights are, right? then when someone tells them that they don't have to do something that's a requirement under federal law, that we need to be equipped with the answer to tell them otherwise. I also think that a lot of this is just decency, right? I mean, and let's treat each other fairly and with grace, and you know, I think our institutions, I think we learned from COVID how fragile our institutions are, and we're now seeing that again with the attack on a lot of our institutions, where it's the institution of public education or the enforcement of our nation's civil rights laws. And we can't just stand by and let it happen without speaking out and just standing up for these protections that have been in the law for decades, that were fought. And I, you know, I think back to the ADA and the Fair Housing Act and all the others. You know, I think the ADA passed with 90% majorities in the House and Senate. Fair housing, once the compromise was reached, was, you know, huge bipartisan majorities. These laws didn't come from a radical perspective. They came from a perspective of decency, of how we want to treat each other. And we need to just, I think sometimes I say we need to model appropriate adult behavior. We need to model appropriate adult behavior, and to not let people's misguided perceptions on what's right and wrong keep us away from demonstrating what the law really does require.
Eliza with them.
I just think, you know, a couple of things. I totally agree with everything Katie said. I think it's very important for people to be advocating at every level here. So I think you need to be advocating with the particular institutions that you're dealing with, your school district, your school, your classroom. But I also think it's very important to be engaged at a national level. Every agency is going to follow up on this executive order with steps to change their existing regulations. Those steps are likely to be illegal or vulnerable to legal challenge at a very minimum, and they will be more vulnerable to legal challenge if, when they do take these steps and they seek public comment, they receive a bunch of comments that explain how important their existing rules are to real people in the world, because the law requires them to take account of those comments and respond to those comments and respond in a reasonable way to those comments. And so, you know, I hope that folks like AAPD and other entities that do advocacy will be helping to give folks information about when is the time to do that. But I also think you need to be doing this very much on a local level, because I completely agree with Katie. I mean, a lot of this stuff is just common sense. It's just human decency. And it's the kind of stuff that, you know, if you're really engaged with your own school district, you can often make a lot of progress on. And, you know, it's terrible sometimes that you have to do that. And that's why we need to have these very strong laws. But it can also create a case and create evidence and facts in the world showing that complying with the law is really not that hard, not that burdensome, and not pernicious in the way that the Trump executive order is suggesting. And that too will be helpful in broader advocacy.
I would also like to add, so I'm in a class right now for law school called Law and Authoritarianism. And I'm writing my final paper right now about like different ways of resisting authoritarianism. And I think it's important to recognize just how important student protest is. Just generally speaking, it's something that is very important. The voice of students in terms of resisting in laws that are unjust, in terms of, you know what I mean, fighting for equality. I mean, that was a huge role in the disability rights movement in the first place, in the civil rights movement, in most movements. Student voice is something that is very powerful. So resistance on a student level, on a campus level, is also something that's very important.
Thank you so much to all of you, and especially you, Yolanda, for taking time out of what must be a very busy period studying for finals. And we we do have a few questions in the Q&A box. The first question is from an anonymous attendee. It said, as a deaf and hard of hearing individual and advocate, Sam mentioned that disability is not the target, but there's still a lot of work to do. Many people face challenges in the workplace getting the accommodations that they need, and it often comes down to either being placed on unpaid medical leave or being fired. Um, in the absence of other remedies, what can we do to stop this? And is there a way to reform the ADA so that this does not happen?
Yeah.
Again, I think this is a place where people need a basic understanding of what the ADA requires. And if someone is, I mean, the ADA in employment says people who are qualified for the job they have need to have accommodations. It's not a question. I mean, it's not voluntary. It's not something you can do if you feel like it, or not do if you don't feel like it. And so, again, I think there are opportunities to file, and sometimes the only way to do that is to file a claim with the EOC to get something investigated. But sounds like, and again, I don't know any of the details, but from what you've said, it sounds like something that's clearly inconsistent with what the ADA requires of employers.
Thank you, Katie. This question is from Priscilla Garcia. What was your experience with deferred impact? And I think that's a question for Eliza.
Yeah, so I was in a very unique circumstance in that, the discrimination that I experienced was very explicit, like very explicit in writing. It came from my guidance counselor, my principal, the superintendent, the assistant superintendents. Like it was essentially all the way up the district, right? Where everyone was in lockstep with this idea that no, they didn't need to do accommodations because for the integrity of the program, I needed to leave. Um, but that wasn't the case. I was not the only student who had a disability or was in need of accommodations at my school, though, and that's where it starts to get interesting. Because when I filed my complaint with the Office for Civil Rights, they didn't just do an investigation into me. They took the data, they did an investigation into the school, and ultimately an investigation into the district and found this pattern in other places as well. Right. And like that's sort of what the challenge is the fact that also when you look at the fact that, when I would very much consider the most of the people that were involved in my high school suit, at least from the district side, to be bad faith actors. When you look at, the behavior it is that they exhibited, you know, the idea that they wouldn't also do this to other students is just something that's not very likely. But then when you look at the fact that all of these students, not all of these students have, you know what I mean, the urge or the timing or the capability or the knowledge to bring the issue to the Office for Civil Rights. So if you're looking at a circumstance where there's somebody who is, you know what I mean, out here deliberately funneling out disabled students, if you find the person who is willing to take this up, and then you can find the data pattern that shows this was the case, as what happened when the Office of Civil Rights looked into my situation. And the report was like something like 300 pages long. Like a lot of stuff was happening there. But when you look into that, um, that's really what you can find. And that ultimately is why disparate impact is so important, because of the fact that it helps to prevent these sorts of challenges to happening to other students when students do bring these complaints and they're found to be legitimate.
Thank you, Eliza. This is a two-part question from Harold Wagner. He writes, does the U.S. president have the legal authority via an executive order to change, weaken, or eliminate federal regulations that were executed under a legal, congressionally authorized process in the prior administration? And the second part is, does an executive order have any legal effect on the requirements of accessible education that are rooted in state law and not federal?
Yeah, so let me take these on. I mean, so the first thing to understand is the president has only that authority to make regulations or change regulations that Congress has given him. And for the most part, regulatory authority is actually in the agencies, not in the president. So that's why you see lots of executive orders, including this executive order, essentially directing the agencies to undertake a process to consider changing the regulations. Now, Title VI is a little different because Title VI of the Civil Rights Act in 1964, the Congress thought it was so important that you had high-level sign-off on the regulations implementing that statute, that those regulations actually require specific presidential approval. That's really, 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 really unusual. Usually it's just the agency that has to do that. And so one little piece of this executive order withdraws the president's approval from a couple of the disparate impact regulations adopted by the Department of Justice, but not by any other department in the government. For the other departments, it just requires that the process take place. Now, that the agencies undertake the process to, consider changing the regs. We have seen already, though, some of the agencies acting super aggressively. The Department of Energy has come out with what is called a direct final rule that bypasses the ordinary notice and comment regulatory process to eliminate its own disparate impact prohibitions. And that is something that is procedurally very irregular. I would say it is not a proper use of the regulatory process, which requires notice and comment. This does not come within any of the exceptions. And I'm sure that's going to be argued, and they may pull back their regulation. And if not, there will certainly be lawsuits filed. But the general answer is no. The president can't just override existing regulations. There's a process set forth by the Administrative Procedure Act for that. The next point about state and local. So this executive order actually does have specific provisions directing agencies to consider essentially whether to file lawsuits against disparate impact prohibitions that were adopted by states. Now, it seems to me very, 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 very unlikely that that's going to capture state and local disability accessibility requirements. Again, the focus here is really on race. But that could still have a substantial effect on individuals with disabilities. The legal arguments for challenging state-level race-based disparate impact requirements just wouldn't apply to state-level disability accessibility requirements. But again, because of the overlap in terms of communities affected, I think you could see a real effect on disabled people, even if all that fell was the race-based disparate impact laws at a state level. But again, that would be something that a court would ultimately decide.
Thank you all. We are just about at time. I do see a couple more questions questions in the Q&A. Do you guys have time to address two more questions? Um, One is from Jason Green. I am currently a student at Cal State Long Beach, and I have seen very little representation. I worry that this will only get worse. What do you think is one way that we can help the transition from K-12 special education to higher ed, since there are different laws governing these two different uh, phases of education? Katie, I think this
Mhm.
question would be best answered by you.
Sure. So a couple things. One is uh, there are academic achievement accountability protocols. So starting in third grade, students have to take standardized tests to see if they are on track with their grade level, mastering their curriculum. In too many states, we have kids who should be able to stay in the general curriculum being tracked off into an alternate curriculum that will take them off the opportunity to get a standard high school diploma. At the end of the day, what we want you to do when you leave high school is have a standard high school diploma and have received transition services so that when a student leaves high school with that diploma, they have some idea of what it is they want to do. Do they want to go to college? Do they want to go to community college? Do they want to go into a trade? Do they want to do something else? And that piece of transition is a place where the previous administration had focused a lot of time to try to make that work better. I think that's a place where we're seeing that as a barrier of students not getting those supports the way the law says that they should. And prior to that, that students are getting sidetracked based on low expectations of the adults in the system, um, about what they're capable of when they're 8. I don't know about you, but I did not have my act together when I was 8. I was 8. I was learning, and so to have someone make a decision that you will never be able to do grade level work when you're 8 is a pretty big decision. And we want to make sure that parents and students are educated about the consequences of those decisions, because that makes the pipeline of people who might want to go to college that much smaller. So I think it's a place where we need absolutely more people. We need to push families as well as students to assume that they can before they assume that they can't, and that it's getting that high school diploma gives you more choices. Doesn't mean that if you don't get it, you have no choices. That's not it at all. But if you do have a high school diploma, you have more choices.
Eliza, can you expand on that as someone who's experienced that transition?
Yeah, I think that the transition is something that's really difficult because it's so decentralized. Like every school, like I've gone to 3 different higher ed institutions now, and the process of getting accommodations and the accommodations that were offered at each space, especially considering each program is different too. Like even the accommodations that I would need in law school are very, very different because of the fact that law school classes are run very differently than my master's program, which was at the Grad School of Ed, versus when I was at college. So I think it's really hard without me actually knowing what the school is. But I know that orgs like Disability Rights California are really helpful in terms of, providing uh support, especially for people that actually know the system better. So like without, sort of overstepping and providing advice that probably wouldn't actually be helpful, that would be what my suggestion there would be, at least coming from me.
Thank you so much, everybody. We are at time again. Thank you, everyone, all three of you, for coming on and being part of our panel today. We will be sending out this recording to all the participants that registered today to attend. And if you have other questions that come to mind after we end here today, you can feel free to email me at mlewis@aapd.com. I will put that email in the chat box. And if it is a specific question for Eliza or Katie or Sam, I can forward that question to them and get you an answer. So once again, thank you all for joining us today and have a great rest of your week. Take care.